He got his PhD in physics from the University of Illinois. He does physics and engineering. He's been involved in forensic science for a long career. He also has got a law degree. He's published. He's spoken all over the world. He's been a professor. He's been a lawyer. But I came to know him when he was president of the American Academy of Forensic Sciences. And he came to ASU where I was teaching right after the National Academy of Sciences had released its report on the forensic sciences, which I'm guessing Dr. Bohan will talk about. And it struck me as, I don't know why, it struck me as unusual that a scientist would be involved in forensic science. And you'll come to find out why. I mean, many in the forensic sciences have no background in science. They're not scientists at all. I also remember that Dr. Bohan at that conference didn't just talk about the National Academy's report that investigated a lot of the different forensic sciences, but he also stepped into an area that you'll hear me talk about later that I'm very interested in, which is shaken baby syndrome, and stood up in front of a lot of people and sort of gave it some notice of, oh yeah, and that shaken baby syndrome stuff is just the same. It has no validity and no reliability. And I thought, that's interesting. And I'm glad he put it on the radar screen. So anyway, I'm proud to introduce Tom Bohan to talk to you about something he knows a lot about.
Thank you, Carrie. Thank you. Yes, just to identify myself, I'm Tom Bohan, as Carrie said. Yes, I remember very well that day that 2 hours before I became president of the American Academy of Forensic Sciences, the National Academy of Sciences report came out. I'm going to give you a little bit of background to that, I hope, somewhere during the next half hour. I've been asked to speak about three. I, as Carrie said, have a PhD in physics, University of Illinois, undergraduate in physics, University of Chicago. And I worked, well, I guess in my career I've worked for the military, I've worked for industry, I've worked for academia, and sometimes I say half facetiously, it's all bad, but it's been an enjoyable route. I worked after my PhD in experimental physics. I decided I wanted to go into forensic science and work in forensic science, so I decided, well, if you're going to do that, you should go to law school. So I went to law school, and then began to hold myself out as a consultant in forensic science, and it was a long and interesting route following that decision. Let's see here. Yes, these are my topics, which I will perhaps equal amount of time to. The scientific testimony, barriers and gateways of evidence. I'm going to have some suggestions on describing forensic theories and techniques to the public. And then finally, areas of forensic science in which journalists need to be particularly alert to their professional responsibilities. And let me just comment first on that last point. I'm very glad to be able to speak to you today because of the importance that you journalists and you future journalists will have to not just the understanding of the public of scientific issues, but also the public becomes juries. And the errors that journalists make in reporting science that is not forensic science has the risk of confusing the public. But in areas which are going to become issues in the courtroom, the errors or the misunderstandings that the public gets may lead to innocent people being put into prison. Wendy had talked about the disadvantage of following Ray up here at the lectern. I had the disadvantage of following Ray and Wendy. And I was sitting as I was listening to them, and I scribbled down, and I'd be parting from my talk right now, a number of points that I wanted to pick out. One was remorse. Ray's convicted of a crime, heinous crime. All right, now you've been convicted, and in this country, usually that is taken to be the word of the Lord. If a jury of your peers has convicted you, now by God, you are guilty, and if you don't show remorse, I'm going to give you more years in prison. Now, you should understand that a guilty finding simply means a person is found guilty in the law. A not guilty finding means that, or the verdict means that the person has not been proven to be guilty. A person is, in spite of the old saying, you're innocent until proven guilty, the fact is that you are generally you've either taken the cookies from the cookie jar or you haven't. You are guilty or you are innocent. In our justice system, we then see whether we can determine whether the person was guilty before the law. And the presumption of innocence is there. But a finding of guilty does not mean that the person is guilty. And so therefore, we should not have that, that extra penalty added if a person continues to claim to be innocent and does not show remorse. A number of the problem areas in forensic science, whether it's arson, shaken baby, are two that are particularly important. We really should be doing a bifurcation of the findings. There should first be a determination that there was a crime, and then we go and look and see if a particular person has been found guilty of the crime. I noted the description that, that Wendy reported that the Phoenix Fire Department had. The high rate of clearance of arson or arson cases. What does that mean? What in the world does that mean? Clearance of arson cases. That means you assume it's arson and you're trying to determine who did it. And that's not the approach that you should be taking. You do not assume that it's arson. There is an organization, the International Association of Arson Investigators, which is aware of this problem of implying that there is arson before you go in. So they're changing their name to International Association of Fire Investigators. All right. In 1993, the Supreme Court, for the first time in the United States, looked at scientific evidence and established rules for the admission or the exclusion of scientific evidence. This is the famous Daubert case. There had been, for practically a century before that, a rule that if testimony was based, or in other words, testimony, expert testimony, scientific testimony, to be accepted into evidence had to be based upon a theory or technique that had general acceptance within the scientific community, within the relevant scientific community. This is the Fry test, the general acceptance test. You should know that. Because it's still a very important test in determining whether evidence should come in. There was a great deal of concern because first, the exoneration of people who were later determined to be innocent of the heinous crimes they could be convicted of, and a lot of talk about junk science being introduced before the court. So the Supreme Court of the United States in 1993 used the Daubert case to enunciate, or to state, that in federal court, the general acceptance test was not going to be the be-all and all. It was not going to be the one criterion that you had to use. We were going to, in fact, use the federal rules of evidence, which stated that if a witness, because of education or experience, has special knowledge about a matter before the court, that person is allowed to come in and give opinion evidence, as opposed to being a factual witness. He's an opinion witness. As I say, this rule, federal rule of evidence, was permissive. It didn't put any limits on what this person could say once he had been found to be specially qualified because of his experience or his education. So the Supreme Court said, but yes, but the people who devised this rule of evidence, which is 702 for those who are wanting to know specifically which federal rule of evidence it is, that they must have known that, they must have implied that there had to be some reliability test. In other words, the judge is going to be made the gatekeeper. The judge looks at the evidence that's going to come in and determines whether it has indicators of reliability. Because we're not going to let anything in. We recognize the fact that the jury is in a restricted area. They don't get to see all of the scientific literature. They don't get to read all of the investigative reports that have been published in newspapers as well. They just have what is put before them. And very often, they'll have two stories put before them, two opinions put before them by expert testimony. The prosecution is going to come in with an expert witness who says, yes, the scientific evidence shows that this individual committed the crime. The defense is going to say, no, that evidence is bogus. And there's other reasons for discounting, or there's other reasons for discounting it. So the court is saying we've got to have some indicator of reliability for these two sides that we're going to allow in. That's the Daubert test. The court then said, well, you know, most of our federal judges, they went to law school so they never have to look at science again. So we're going to have to tell them a little bit about how they determine reliability. So they said, well, has the technique or the theory been tested? And I always add to this, has been tested and found to be right a high percentage of the time. In other words, that's a test of reliability. The fire dog, for example, would be an example of that. Has that been tested? Is there a record of how many times the dog hit correctly on an accelerant? How many times it missed? That is a test of its reliability. That is a test of its correctness. Also, is this technique, is this theory, has this been published? And are the standards for applying it? And the implication is, and are the standards being used? These are things you look at when you're evaluating what a judge is doing with regard to letting evidence in. And most importantly, is the theory or technique accepted by the scientific community? So we're back to the Fry test again, and I contend that that is the most important test in determining whether or not a theory whether or not a theory can generate testimony that's reliable enough to come to the court of law. Now, the important thing to realize as journalists, as budding journalists, looking at trials, is that, as you probably know, somewhere in the back of your head, we have a federal system, which in this case comes down to the fact that we have a federal system of courts, the federal district court, the federal appellate court, the U.S. Supreme Court, and we have state courts. Almost all the trials that occur take place in state courts. So when the Supreme Court comes down with the Daubert decision, that just applies to the federal courts. It doesn't apply to the state courts. Each state individually has to decide what it's going to use for its gateway, what it's going to use for its barrier to evidence being admitted before a jury. And many of the states have adopted the Daubert theory, the Daubert standard. A lot of them still have the Fry standard. And depending how you look at it, they sort of come down to the same thing. Is there reason to believe the theory is correct, that the individual witness is coming in to testify based upon? All right? Now, people scurried in an unseemly fashion after that case came down, the Daubert case came down, to say, well, that just applies to scientific evidence, or maybe fundamental scientific evidence. Somebody may come in and testify about the equivalent of the universal theory of gravitation. That's what it's about. It's not about an engineer coming in and saying, well, based on my experience as an engineer, or a odontologist coming in and saying, based on my experience with bite mark identification. No, that doesn't apply to that. There we can use just the same type of approach we've been saying before. The guy's qualified, and therefore what he says is admitted into evidence. What's the old ipsa dixit type of testimony? It's so because I say it's so. All right? So the court, in what might be considered very rapid follow-up, considering how slow the justice system moves, about 6 years later, ruled in the Kumho Tire case that no. When we said scientific testimony, we meant all specialized testimony. We went all expert testimony. So the rule about expert testimony now is going to be interpreted for all types of specialties, whether it's a odontologist coming in and talk about bite mark evidence, or it's a automobile mechanic coming in and talk about the failure of the differential gear in the car. It's all going to be subject to the reliability test in federal court. All right, the Kumho Tire. That was great. That was wonderful. Except that most of the states have not accepted the Kumho Tire case. They have not accepted that standard. So if you look state by state, and I think there's something on the website or in the handout, I'd gone through all 50 states at the time a few years ago and stated what their various standards were. Most of the states still identify certain types of evidence as that which requires a reliability examination before it comes in before the jury, and the other stuff which is, well, that's not the type of stuff we need to do that on. So you have to look carefully at the states. Some of the states are very lax and allow in practically everything. My state of Maine is one of them. The state of Wisconsin, said explicitly, you don't have to prove reliability. You just have to prove relevance, and which leaves one sort of scratching one's head about how can something be relevant if it is not reliable. I had I don't know, was a Marshall McLuhan experience or it was a Woody Allen experience, I've forgotten which. Shortly after I'd written about this, all the different states, including Wisconsin, in one of those papers, I sort of make fun of the Wisconsin rules for the very reason I just said. It has to be relevant, it doesn't have to be reliable. I was at a gathering at which I was suddenly introduced to the Chief Justice of the Wisconsin Supreme Court. Wow, what an opportunity. So I talked to her about scientific evidence coming in, and I said, well, I really find it strange in Wisconsin where you can have something that's considered relevant, but that doesn't have to be shown reliable. She said, and she is a respected jurist, she said, well, we think our defense attorneys in Wisconsin are so good that they can show that something is not reliable if it's not reliable. Well, I'll tell you, after 30 years of being in the forensic science business and the lawyer business, I can tell you that ain't the case. Once something is into the trial room, before the jury, you never know what role that's going to have. And they can't be dismissed just by a clever defense attorney. So anyway, Dalbert Kumho, when you're looking at trials, look to see what your state has as its rule for allowing scientific evidence in. All right, suggestions on describing forensic theories and techniques to the public. I think I may have a slide specifically dealing with that. This goes to some papers that I have written, which I think, in fact, are the best description of what the Dalbert case is, but there's been a lot of other papers published on the subject, so other people think that they have something to say about that too. All right, the second part, what can journalists do to educate the public and not contribute to innocent persons being convicted of crimes like child murder? All right. You go beyond, yes, all elementary journalism 101, as they would say, the when, where, why, and so forth. Ask yourself about any factual statements you're going to make. How do I know that? How do I know that? Somebody tell me? How do I know that? I wrote a book a few years ago for forensic science for as Isaac Asimov had in one of his books, Science for the Educated Layman, which then later became Science for the Educated Layperson. This is forensic science for the educated, interested layperson. And I go through a number of cases, some of mine, some others. But what I want to read to you is what I said at the conclusion of people who have now read about all these cases. It's hoped that this book has provided at least the start of the knowledge needed to test for reliability the statements made by others, whether they be friends, scholars, commentators regarding the public scene, and whether they be in written or spoken words. Taking the measure of statements intended to convey information lies at the heart of the forensic enterprise, for which skepticism is the necessary first response, and I would say journalism too. Skepticism. It is necessary but not sufficient, that is skepticism, since it's impossible to investigate everything personally. One must therefore develop reliability gauging rules, enabling one to make use of information appearing in witness statements, in official reports, in public documents, and in internet sources. The preceding chapters have been aimed in part at showing why no statement, no conclusion standing alone should be accepted as true. It is important in an early age to learn not to parrot what one has heard from others as if it were true, that is, factual. And I would say, just as an aside, it's only in the area of law that true fact is not a redundant phrase. Fact, by something that's factual, I mean something that's true. In law, it can mean something that may not be true, but the judge has found to be a fact. It is important to learn in an early age that most of the supposed facts one is told by others have no more significance as indicators than that the person doing the telling has heard or read the statement previously. This lesson can be learned quickly by regularly asking people who relate statements that are supposedly true, how it is that they acquired the information they are relating. One should inquire of a person who just announced some action or some event, whether he or she knows for a fact that it has happened. This can be done without being rude. Now, I want to show you an example of a story that appeared in a source that I normally respect highly. National Public Radio. This was in July. I got so upset when I heard this story. This is a part of the transcript of the story. And the thing, I just want you to sort of read through this quickly as you can. The story was by a freelance reporter. I contacted her after this, and then later when I found I was going to be at this workshop, and the subject of the workshop, I suggested that she come to this workshop because she certainly needed to have some of the lessons that would be taught at this workshop. All right, the problem here, she has this story about, well, how are we going to tell the better way to diagnose shaken baby syndrome, all right? So, shaken baby syndrome, and I'm going to get ahead of the story a little bit here, but we're going to be repeating a lot of things here, and they should be repeated. The shaken baby syndrome is as follows, shaken baby syndrome theory. If a dead baby or a dying baby is presented to you, and that baby has hemorrhages in his or her retinal hemorrhages, some swelling of the brain, and subdural hematoma or more, then that baby, and no other injuries, this is the key to this terrible theory, no other injuries. Well, you know, you're not supposed to shake babies. You know, when you're handed a young baby, you're, oh, hold the head, you know, the next very week. Can you imagine shaking this baby without hurting its neck and killing it? No, you can't, all right? So that's what the shaken baby syndrome theory is. So, fortunately, starting about 15 years ago, there's been a response from physicians and others who know something about physics to say that, you know, that's not been shown, that's never been shown, and then the more you look into it, and geez, I don't think it's true. But at the very least, it's never been shown to be true. All right, so this reporter says, okay, we assume there's the shaken baby syndrome theory is true. We start assuming that this theory, which is in great doubt right now and great attack right now, and I personally, after looking at this for many years, I'm sure, well, it hasn't been established, and the most logical conclusion is it is nonsense. What does she say about the attack by scientists, by physicians who have scientific sense, and by engineers and by physicists? She said, in recent years, a small cadre of experts testifying for the defense in cases across the country has called into question whether these symptoms are actually indicated abuse. So they, this cadre, the last time, and the only time I'd heard this expression other than this had to do with the Cultural Revolution in China. They talk about the cadre of Chinese soldiers coming around with novels. Cadre, clever word. Though they are in the morning, disputing a consensus. What's consensus mean? That means sort of like everyone believes it, everyone accepts it. The consensus of child abuse experts, etc., etc. You know, they've gained traction. Oh my God, these people who are questioning have gained traction. Well, this can't be. So along come the physicians who have a new theory. Well, this is the way you tell. I don't have the rest of the story here, but what she says is, and what they say is, yeah, well, if you have those three symptoms, and you also have a bunch of fractures in the ribs, or maybe the legs, then this really shows abuse. They don't say anything about, well, let me back up a little bit. What they're saying is that you have a child which has clearly been abused, then these three symptoms, the retinal hemorrhage, the subdural hematoma, and the brain, then that triad shows abuse, if you have all these other things. So anyway, this story was complete and utter nonsense. This is the type of thing you need to avoid. Don't accept something as established and then go on to work on the finer details of it. All right. I don't want to get too far into the shaken baby syndrome because we're going to be talking about this in some length. And I think that it's mentioned on the website, Deborah Turkheimer's book that came out about 3 years ago. So this is a former federal prosecutor, also an undergraduate degree in science. She was a professor of law at the University of Maine Law School at the time she started working on this. She's now at the University of Northwestern University Law School. And she wrote a couple of papers. She got an op-ed, there was an op-ed in the New York Times for which she literally received death threats when she said, you know, this theory really hasn't been established. I mean, as an aside, I'll say that one of the things you notice is when the prosecutors have fingered somebody for having murdered a child, for example, or having burned down your house and murdered your mother, once the prosecutors have claimed this, then the family sort of gathers around behind the prosecutor and they really want to convict the person who's been charged. So, all right, she says, well, you know, this theory really hasn't been shown, and this sort of shakes these people up who thought that they had put away the person that had done the evil. All right, about 20 years ago, was working with a program run by the American Institute of Physics, in which for universities that had a program in physics through the master's degree but didn't have a PhD program, the AIP would finance a trip by a physicist to come and give talks. And I had volunteered to give talks on forensic science, or a physicist does patent law. Well, there weren't any calls for that, but there were a lot of calls for forensic science. And I went around, I called it the program for relief for superannuated physics professors. And so I would go around, upon being invited to different schools, and would generally always talk about my forensic cases, you know, civil litigation, accidents, crimes that I worked on, cars I burned up as part of my investigation, things like that. And then I was invited to Boise State University, where the head of the physics department was Dick Ryman. And he said, I want you, what was this, about 15 years ago, 17 years ago, I want you to look into the physical evidence supporting the shaken baby syndrome theory, okay? At that point, like probably most of you even today, and certainly like the vast majority of people in the United States, I thought, oh yeah, that Louise Woodward case in Boston where somehow they let her go back to England even though she'd been convicted. So I had an office staff and I asked somebody in there to go and get me all the papers on shaken baby syndrome. And at that time, it was only that high, the stack of papers. And so I started reading through them. And I was about halfway through and it began to dawn on me that there's nothing here. There's nothing to indicate that what they're saying is correct. And this triad supports the accusations that they're making and that these people were quoting each other. I remember my favorite one was the guy that says, oh yes, and for this to occur, that is for you to kill the baby by shaking it without harming its neck and thereby create the triad, you had to shake it at a frequency of at least 2 hertz through at least 3 cycles. What? I mean, where does this come from? There's nothing there, all right? And so that's when I realized that, and ever since then I've been working with the evidence-based medicine group to do what I can to bring to light the fact that this is not a valid theory. And yet it's still to this day being used to send people to prison for a long time. I mean, you can drunkenly have a motor vehicle crash in which there's 4 people killed, and in most states, at most you'll get 5 to 10 years in prison. These people are being sent away for 40 years. 40 years, and then there's one case in Colorado, he got 2 consecutive, you're talking about the consecutive sentences, 2 consecutive sentences of 40 years by having been convicted based upon this theory. All right, so what else do I have? Let's try time on that. Open up the other. Yeah, I know. I don't want to go with the rest of this at this point. I want to get into my other. Can you help me with this? I want to get pull the other PowerPoint file here. Match here. Well, the fact is that a lot of people, there is a match, or there is an apparent match. But that doesn't mean that they were the one that hit the victim. And this is what's been unfolding now in the last 15 years around the country. That thanks to DNA evidence, they've been able to exonerate people who were convicted. So the fact that the bite mark appears to match the dentition of the defendant does not mean the defendant made the bite mark. But it has been much harder to get these people exonerated. Like impossible, well, like Ray, he wasn't exonerated. I mean, the first time around where you got the DNA evidence, talking about prosecutors who see the conviction in a death case helping them go up the ladder, the governor, maybe, reminds me that when the first DNA cases were coming out, they didn't even have that much excuse. They didn't have that much explanation. Oh yeah, a lot of people at the bar, maybe they spit on her earlier in the evening, and that's why they got their saliva there. But the one prosecutor says, well, you have your DNA evidence of exclusion, but I have an eyewitness. I have an eyewitness. Eyewitness evidence is the worst possible evidence. It is not the gold standard. You often hear, well, there's only circumstantial evidence here. Let me tell you, all the evidence that works, all the evidence that's correct is circumstantial. What do they mean by only circumstantial evidence? They mean it's not eyewitness, and that the guy didn't confess, so it's just circumstantial. Eyewitness testimony should not be allowed in. One of my favorite double takes when I was testifying, it was a court in New York City. It was a civil case, and the attorney, the city was the defendant, a nice young woman, the defense attorney. She was left-handed like me, and I sort of had sympathy for her. At one point in the testimony, across the examination, oh, this was right after the Bonfire of the Vanities book came out. I don't know if you've heard of Tom Moll's Bonfire of the Vanities. It really is like that. The judge was on the telephone, part of the trial, smoking and so on. In any event, the defense attorney said, well, now, in a case where there's no where there's no eyewitness testimony, physical evidence becomes very important, doesn't it? And my reply was, not nearly as important as it becomes when there is eyewitness testimony. And the judge put down the phone and looked, and she did a double take. And then I explained that if you have eyewitness testimony, the juries across this country, the judges across this country, probably the lawyers across this country, still think that's the best, that's the gold standard. So if you have eyewitness testimony, the worst is a single eyewitness. Better to have two or three, because then they tend to contradict one another. Best is to have, if you have eyewitness testimony, have lots of eyewitnesses, because they either contradict each other or all say basically the same thing. So you've got eyewitness testimony, which is probably wrong, and so you can use the physical evidence to show what really happened. Oh, I will say that I was going to recommend that you all get my book, which came out about 7 or 8 years ago, but I just checked on Amazon.com, and it is it's regrettably out of print. But I do have, I understand, a Chinese version coming out next year. I will leave you with that, and thank you very much for your time.